The Code of Criminal Procedure 1973 एक्ट नंबर 2 है ऑफ 1974। प्रेसिडेंट ने इसको साइन किया 25 जनवरी 1974। 1 अप्रैल 1974 को इन्फोर्समेंट है। प्रियम्बल इसका एन एक्ट टू कंसोलिडेट एंड अमेंड द law relating to criminal procedure, be it enacted by the Parliament in the 24th year of the Republic of India as follows. Chapter 1 Preliminary. Section 1 Short Title, Extent and Commencement. This act may be called Code of Criminal Procedure 1973. Subsection 2 it extends to whole of India, जो कि 31 अक्टूबर 2019 से लागू है। Provided that provisions of this code other than those relating to chapter 8 जो सिक्योरिटी से रिलेटेड है, चैप्टर 10 पब्लिक ट्रंक्विलिटी से, चैप्टर 11 प्रिवेंटिव measures से, thereof shall not apply to the state of Nagaland or to the tribal areas, but the concerned state government may by notification apply such provision or any of them to the whole or part of the state of Nagaland or such tribal areas as the case may be, with such supplemental, incidental or consequential modification as may be specified in the notification. Explanation. In this section, tribal areas means the territory which immediately before the 21st day of January 1973 were included in the tribal area of the Assam as referred to in the paragraph 20 of the 6th schedule to the constitution, other than those within the local limits of the municipality of Shillong. It shall come into force on the first day of April 1973. Section 2 Definition. In this code, unless the context otherwise requires, a bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. B 2B में है charge includes any head of charge when the charge contains more heads than one. C cognoscible offence means an offence for which, and cognoscible case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. D complaint. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offence but does not include a police report. Explanation. A report made by police officer in a case which discloses after the investigation the commission of a non-cognoscible offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be a complainant. 2E में हाई कोर्ट है. हाई कोर्ट मीन्स इन रिलेशन टू एनी स्टेट द हाई कोर्ट फॉर दैट स्टेट. In relation to union territory to which the jurisdiction of high court for a state has been extended by law that high court. In relation to any other union territory, the highest court of criminal appeal for that territory other than Supreme Court of India. F में India. India means territory to which the court extends. 2G inquiry means every inquiry other than a trial conducted under this code by a magistrate or a court. 2H में investigation includes all the proceeding under this code for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this behalf. 2I में judicial proceeding includes any proceeding in the course of which evidence is or may be legally taken on oath. 2J में local jurisdiction in relation to a court or magistrate means the local area within which the court or magistrate may exercise all or any of its or his powers under this code, and such local area may comprise the whole of the state or any part of the state as the state government may by notification specify. 2K में metropolitan area. Metropolitan means area declared or deemed to be declared under section 8 to be a metropolitan area. 2L non-cognitive offense means an offense for which, and non-cognitive case means a case in which a police officer has no authority to arrest without warrant. 2M notification means a notification published in the official gazette. To an offense, it's very important, means any act or omission made punishable by any law for the time being in force, and includes any act in respect of which a complainant may under Section 20 of the Cattle Trespass Act 1871. To whom officer in charge of police station includes when the officer in charge of the police station is absent from the station house or unable from illness or other cause to perform his duties. The police officer present at the station house, who is next in rank to such officer and is above the rank of constable, when the state government so directs, in any other police officer so direct. 2P में place includes a house, building, tent, vehicle and vessel. 2Q pleader when used with reference to any proceeding in any court means a person authorized by or under any law for the time being in force to practice in such court, and includes any other person appointed with the permission of the court to act in such proceeding. 2R में police reporter means a report forwarded by the police officer to a magistrate under subsection 2 of section 173. 2S में police station means any post or place declared generally or especially by the state government to a police station, and includes a local area specified by the state government in this behalf. 2T में prescribed means prescribed by the rules made under this code. 2U में public prosecutor means any person appointed under section 24 and includes any person acting under the direction of the public prosecutor. 2V में subdivision means subdivision of a district. 2W में summons case means a case relating to an offense and not being an warrant case. 2WA जिसको 2008 में अमेंड ऐड किया गया है, इन्फोर्समेंट डेट 31/12/2009 है. Victim means a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. 2X में warrant case means a case relating to an offence punishable with the death, imprisonment for life or imprisonment for a term exceeding 2 years. 2Y words and expression used herein and not defined but defined in the Indian Penal Code have meanings respectively assigned to them in that code. Section 3 Construction of references. Section 4 Trial of offences under Indian Penal Code and other laws. Subsection 1 All offences under the Indian Penal Code shall be investigated, inquired into, tried or otherwise dealt with according to the provisions hereinafter contained. 2 All offences under any law shall be investigated, inquired into, tried and otherwise dealt with according to the same provision, but subject to any enactment for the time being in force regulating the manner or place of investigating, inquiring into, trying or otherwise dealing with such offences. सेक्शन 5 सेविंग की बात करता है. चैप्टर 2 कॉन्स्टिट्यूशन ऑफ क्रिमिनल कोड्स एंड ऑफिसेज. सेक्शन 6 Classes of criminal courts. Besides the high courts and the courts constituted under any law other than this code, there shall be every state the following classes of criminal courts, namely Court of Session, Judicial Magistrate of first class in any metropolitan area and Metropolitan Magistrate. Third, Judicial Magistrate of the second class, and fourth is Executive Magistrate. सेक्शन 7 टेरिटोरियल डिवीज़न और प्रादेशिक खंड। प्रत्येक राज्य एक सेशन खंड होगा, प्रत्येक राज्य एक सेशन खंड होगा या उसमें सेशन खंड होंगे और इस संहिता के प्रयोजनों के लिए प्रत्येक सेशन खंड एक जिला का होगा या उस जिले होंगे, परंतु प्रत्येक महानगर क्षेत्र उक्त प्रयोजनों के लिए एक पृथक सेशन खंड और जिला होगा। Second clause, the state government may, after the consultation with the High Court, alter limits or number of such division and district. Third, state government may, after consultation with the High Court, divide any district into subdivision and may alter the limits or the number of such subdivision. With the session division, district and subdivision existing in a state at the commencement of this code shall be deemed to have been formed under this section. Section 8 Mahanagar Kshetra Metropolitan Area. The state government may by notification declare that as from such date as may be specified in the notification, any area in the state comprising a city or town whose population exceeds 1 million shall be a metropolitan area for the purpose of this code.